Hello and welcome to our video on Unit 6, Chapter 4. We're going to be talking about civil liberties today. All right, here we go. The history. When we talk about civil liberties in the United States, it begins with George Mason. He was the first to propose the Bill of Rights in April of 1789 at the Constitutional Convention. It was quickly dismissed by the other members of the delegation. Why do you think it was dismissed? Take a minute and think about that. It was dismissed mainly because of the fact that the Founding Fathers believed that these types of issues were going to be addressed at the state level, and there was really no need for the federal government to get involved in laying out these different protections because, again, the idea was, yes, we were going to have a more powerful federal government, but that the state governments were going to take care of these specific issues. When the states were faced with this new Constitution, when the Constitutional Conventions were set up from state to state and then the new document was submitted for ratification, the issue came up again. Again, it was something that was passed over by these founding fathers at the Constitutional Convention, but then brought up again when it was time to ratify this new plan for government by the states. The anti-federalist faction, who were not delegates at that convention, brought up this idea and really did not like the fact that this new government, there were no protections included. This was really supported by Thomas Jefferson, who wasn't a delegate and who was actually in France at the time. And again, but he was supportive of the idea that the Constitution would be imperfect without the inclusion of a Bill of Rights. Right, this division and discussion would eventually lead to compromise, and an unwritten pledge was made by the Federalists to those anti-Federalists and those members that were nervous about not having a protection of rights included. They agreed to have a Bill of Rights added to the Constitution or amended once it was ratified, and eventually these are going to become the first 10 amendments of the Constitution, the Bill of Rights. Madison did support the addition of the Bill of Rights to the Constitution, mainly because he wanted to gain the support of the Anti-Federalists. Many of these Anti-Federalists from the South were going to basically become a tipping point in the adoption of the Constitution. All right, so civil liberties definition-wise, and again, these civil liberties are oftentimes confused with civil rights. Civil liberties are the protection or the protections of citizens from improper government action. They are the legal and constitutional protections in place against the government. All right, so they're there to protect us from the power or the powers of government. A Bill of Liberty, what people are entitled to against every government on earth. So again, these ideas that we find in the Bill of Rights are not just protections from the American or this new form of government, but these were viewed as protections, universal protections from governments that all people should have. If you take a peek at the Bill of Rights, and you should, the amendments, the 10 amendments, really focus on what the government cannot do. They don't really lay out any rights or freedoms. They discuss specifically what the government cannot take away or do. Here's some examples. Congress shall make no law. The right to bear arms shall not. No soldier shall. No warrant shall be issued. No person shall be held. Excessive bail shall not. So again, you'll see here from these examples, working our way through all of the Bill of Rights, from the Second Amendment to the Third Amendment, you see examples here specifically laying out what the government cannot do. And again, these are derived mainly from the history of things that the monarch had done to the British colonies and this idea of tyranny. Okay, so the Bill of Rights then and now. The Bill of Rights, when initially adopted, protected only the freedoms of the people from the national government. Okay, we're talking about the federal government. These freedoms were not necessarily guaranteed to be protected from state governments. So this Bill of Rights only applied when it was adopted in 1789 to protecting citizens from the national government. It did not protect them from state governments. This was challenged by the Barron v. Baltimore case in 1933. The Supreme Court ruled that the Bill of Rights did not protect individuals against state governments. So that's 1833. The Supreme Court makes this decision. All right. Fast forward almost 100 years later, the Supreme Court changes its mind with the Gitlow versus New York case. And this reverses Barron versus Baltimore, and the court uses the Due Process Clause of the 14th Amendment. So the 14th Amendment adopted following the Civil War, which creates a citizenship clause and a due process clause. Again, the original intent here was to protect newly freed African Americans. But it's going to be used by the court to extend that due process protection to all citizens. Citizens from the federal government and citizens from their own state governments. And there's the actual text from the 14th Amendment. No state shall deprive any person of life, liberty, or property without due process of law, or deny to any person within its jurisdiction the equal protection of the law. So under that clause, the due process component of the 14th Amendment, the Supreme Court changes its mind, all right, and begins the process of incorporating or pushing that protection of the National Bill of Rights down to citizens of each state from those states. All right, in the Gitlow case, we're talking about First Amendment right against state abuse. This Gitlow decision establishes the incorporation doctrine. The Supreme Court has gradually, on a case-by-case basis, ensured or extended the protection of most of the freedoms that are listed in the Bill of Rights down to the states, protecting them from being infringed upon by state governments. All right? Not all of these have been incorporated to this point. So all 10 amendments have not been incorporated. Again, it's a case-by-case basis, but most of them have. All right, a good example, there's the Second Amendment, which has had some more modern cases, but has not been fully incorporated. All right, you have a sampling of these incorporation cases in the civil liberties section of your case review. Make sure to take a peek at those. Again, this process is known as selective incorporation because it's not a blanket. It's a case-by-case basis. All right, let's talk a little bit about the freedom of religion in the First Amendment. Okay, the First Amendment has two separate clauses. We have the Establishment Clause and the Exercise Clause. The Establishment Clause basically lays out that Congress cannot make any law establishing any religion in conjunction with government. A loose interpretation of the Establishment Clause would force you to believe that the government should not favor one religion over another. A more strict interpretation of this clause basically endorses a total separation of church and state. All right, again, so how you view this, do you have a more activist or do you have a more constructionist view of the statements contained in the Establishment Clause? Well, that's going to dictate how you feel. This clause has really been the focus of debate over prayer in schools and how much money the federal government can give to private and religious schools throughout our history. A couple cases dealing specifically with the Establishment Clause was the Lemon case. The Supreme Court ruled that the federal funding of religious schools is okay as long as that money does not go towards specifically religious education. It can go towards administrative purposes and other functions, but not specifically religious teaching. We also have the Engel-Vital case. And again, this is one of the cases that was going to lead to any real forced prayer in school to end. Federal funds cannot be used to endorse any type of religious teaching. And student religious groups, since we have a tax-supported system, a public-supported school system, we're talking about public schools here, cannot be denied access to facilities, to buildings for the purpose of meeting or worship if other similar groups are allowed access. Here we have a Muslim Student Association who uses the building to pray on Friday afternoons. We have other religious organizations that will use this building on the weekends. So all of those things are allowable outside of school hours. All right, the other clause in the First Amendment is the Free Exercise Clause. That's the freedom or practice to either practice or not practice any religion. Here in the United States, you don't have to believe or practice a particular faith if you don't want to. The Supreme Court has really upheld this idea that you can't infringe on the way people worship. If you want to go out and you want to worship nature, you can do that. What the government does regulate is behavior. Religious practices are confined by whether they conflict with other laws and whether they are breaking those laws. All right, you can infringe upon others' religious worship with your worship, and you cannot break the law when worshiping. It's a good rule of thumb when looking at the free exercise clause. Okay. As we go forward here, you'll see First Amendment with the freedom of speech and expression. We're going to talk about these other components of speech. We're going to talk about prior restraint. We're going to talk about all of those issues in class. Thanks for watching this video dealing with Topic 1, Civil Liberties. Make sure that you fill out the Google form.